Hi, my name is Jimarielle Bowie, and I'm going to talk to you today about if you can file a restraining order on behalf of your child. So a restraining order can be filed for a child, and it can be done in multiple different ways. So if you're seeking protection, you can find the most advantageous thing for you. The first way and the easiest way is if you are filing a restraining order on your own behalf, you can file for that restraining order, and you can request that your child is included in that restraining order. It's important to keep in mind that it's a lot easier if your child lives in the home with you, but they can still be included in some cases for other contexts as well. So if you on your own are filing for a restraining order, you can include your child on that restraining order as well. That's probably the easiest way to go about it, because then you can just prove your case along yourself. However, if there are other issues, such as if parents are sharing custody between children or any other circumstance where there's some kind of custodial battle, it may be harder. And so another way that you can file for a restraining order on behalf of a child is by filing for them on their own. And what will happen is typically you will have a person called a guardian ad litem, or just a person from the court that is appointed to represent your child. In most cases, a child under the age of 12 cannot represent themselves, obviously, because they probably lack the capacity. And so a person will be appointed in that regard. But if they are 12 or older, they are able to represent themselves. While a parent can probably help them out with filing, they are able to file a restraining order for themselves and defend themselves or represent themselves in a restraining order matter. So a child over the age of 12 typically can just file on their own or have their parent file for them. But for a child that is under the age of 12, a parent can file for them, but they will probably need a guardian ad litem or someone from the court that is appointed to them to help represent them and decipher for them. And also, a guardian ad litem typically cannot be a parent, or cannot at all be a party to the action. So in some cases, a parent may be a guardian ad litem or be appointed for them, but it's really rare, just because a lot of times the parent themselves is also a party to the case. And again, they cannot be a party to the case. But essentially, those are the two avenues by which a person can file for a restraining order on behalf of a child. The first and easiest step is to include them if you're filing on your own behalf. But if you're filing just for the child and themselves, then they need to either if they're under the age of 12, they need to have someone appointed to them to continue, because they're unable to represent themselves. Or if they're over the age of 12, they can have the assistance of a parent or a support person, but they can also represent themselves because they have the capacity to. If you find yourself needing protection for a child through the means of a restraining order, please reach out to the Nieves Law Firm and see how we can help you.